Hello everyone, welcome to this video. In today's video, we'll be considering the relationship between liberty and the law. Now, liberty and the law are two fundamentally important concepts that are often intertwined, but they can also come into conflict with one another. So in this video, what we aim to do is to explore what these concepts actually mean and how they relate to each other in practice. We'll also discuss how we can ensure that the law best protects our liberty without infringing upon it. We know from experience and from history that the law is one of the best mechanisms of tyrannical governments to control and oppress its citizens. So I think today's concepts that we're going to explore are intrinsically important to us in our daily lives. So while the law can work to protect individual freedoms, we've just stated that they can also be used to infringe them. An example of this two-sided nature of, if we can call it that, of liberty is the law protecting free speech. So in the US, the First Amendment of the Constitution, which guarantees the right to free speech for all citizens. This freedom means that individuals are allowed to express their opinions, beliefs, and ideas without the fear of government censorship or punishment, being cancelled, I guess, as well. However, there are limitations to free speech, such as speech that incites violence or presents a clear and present danger. In addition, there are also laws that protect individuals from hate speech and harassment. A brief overview before we start. The tradition of liberalism in political philosophy has played a vital role in shaping Western legal and political systems. Liberal approaches to law are generally characterized by adherence to constitutional principles such as the rule of law, the separation of powers, access to due process, and other fundamental human rights. Liberalism is the political philosophy which places emphasis on the importance of liberty, right? So in this video, we consider the relationship between liberty and the law. It's a pretty vexed one. But before we do that, we'll have a look at specifically the meanings of terms. So what is liberty, first of all? And then what is law? And how are the two related? What kind of laws best facilitate the protection of liberty? And that's something that we can consider on the back of actually examining those two concepts to better assess or conclude what measures can be taken to best protect liberty. We first need to know what these concepts are. So just to give you some food for thought, I've presented a few statements on the screen if you have a look, and these are popular presumptions, and I want you to consider whether they are true or false. So regarding liberty, is inextricably linked to positive outcomes. Liberty is best protected by democracy. Regarding law, laws must be made by persons or individuals or a state comprising individuals. So here, basically what I'm trying to get you to think about is whether it has to be man or human made in order to be a law. And then another statement is laws must not change in order to be fair. So the direct correlation between the unchanging nature of law, an immutable law, and fairness or equality even. Regarding the best measures of protecting liberty through law, have a think about whether bigger states best protect liberty and whether the law is responsible for ensuring equality in order to achieve liberty. So must the law ensure equality in order to achieve liberty? So is liberty a means to an or equality is the end and liberty is the means to that end? And must the law first ensure equality? So those are some statements you can have a think about. I'll let those mull in your mind while we look at more specifically the two concepts of liberty. So liberal political philosophy emphasizes the importance of liberty. A distinction is often made between negative and positive conceptions of liberty. Negative liberty can be understood as freedom from intentional interference with one's actions by the state or other persons. On the other hand, positive liberty can be understood as the liberty to pursue some other beneficial ends. So, negative liberty is often associated with the preposition from. So, liberty from intrusion or external interference, whereas positive liberty is commonly associated with a preposition to. So a liberty to do or to have something. Now, Isaiah Berlin made the penetrating observation in his famous essay, Two Concepts of Liberty, which was published by Oxford University Press in 1969, that those subscribing to these two different notions of liberty often fall into antithetical political camps. So those who adopt a negative view of liberty as the primary political value are known as classical liberals, and they are defenders generally of constitutional governments. They want small or minimal states, and they often pursue the equality of opportunity. On the other hand, those who adopt the positive view of liberty as the primary political value are known as social liberals. And their ventures are often characterized by cooperation with big companies and labor unions. They pursue centralized governments in their political philosophy or commitment, and they fight for equality of outcome as opposed to equality of opportunity. All right, so let's have a look at political philosophy more broadly. So I'm just going to take a step back and look at it from a big picture perspective. Political philosophy is a compound word in linguistics. When we unpack this single concept, political philosophy, we can do so by considering each singular component before trying to understand them together. So let's first take out the second word, philosophy. Now, philosophy comes from the classical Greek word philosophia, and philo, another compound, I suppose. Philo means love, and sophia means wisdom. So philosophia means love of wisdom. Keep in mind that in the classical Greek philosophical tradition, this basically point to questions, a methodology of asking questions like the Socratic method, which basically asks you to interrogate first principles. So Penguin Dictionary of Philosophy defines philosophy as the study of the most fundamental and general concepts and principles involved in thought, action, and reality. Obviously, those thought, action, and reality pertain to human beings. So contrary to what modern and ordinary meaning has come to convey philosophy as, like as something that's fluffy and theoretical, I guess, originally what philosophy represented was continuous with the best practice in any field of intellectual inquiry. And the Oxford Dictionary of Philosophy encapsulates that by saying that many of the early philosophers were mathematicians, biologists, astronomers, and like those teachers of logic. Even in today, the practical or technical meaning of philosophy engages with logical reasoning. And this forms the cornerstone of the philosophical tradition, even today. So let's consider the second compound word, which is the first one, political. And political comes from the classical Greek word politia, meaning political thought, especially in the writings of Plato and Aristotle. And Plato wrote The Republic, one of his most famous works. And the word politia is derived from the word polis, which means a city-state. Importantly, politia refers to the ways humans organize themselves in societies in relationship to power, right? Therefore, some key concepts to keep in mind are human nature as well and political power. All right, so liberalists and the state. Liberalists hold a skeptical attitude towards the state, and this is because all state actions in one way or another encroach on our negative liberties. Whether that's justified or not is a separate question, and libertarians will argue that hardly any of those encroachments are justified, whereas classical liberals will concede that in some cases, for the common good, for the provisions of basic goods and services, we must willingly or consensually allow that our negative liberties be constrained. Now, the most obvious example is taxation. Regardless of the purpose of taxation, whether it's to advance positive liberty, it must first involve a necessary infringement of our freedom from financial constraint. And so this one has a tricky one because, for example, the American Revolution against the British monarchy was founded upon the slogan, "No taxation without representation." So it's the idea that they needed to consensually relinquish their negative rights in order for the government to validly tax them of their money. All right, so liberalists also concede that sometimes our liberties are legitimately constrained. So they're based on the presumption that liberty is not absolute. At the point where one's liberty is injurious to another person's fundamental interests are required to be restrained in order to advance other important social goals, like providing basic education, hospital care, etc. No matter, liberalists ultimately believe that any constraints of negative liberty must be strictly proportional to the achievement of the legitimate ends to which the government is trying to constrain them. Most liberals believe this would translate to a minimal state. So classical liberals still believe in a small government composed of like merely a police force and a judicial system. A political system based on constitutional law is the preferred political arrangement. So constitutional law's main purpose is to place limits on government power. And this is seen as compatible with liberal political philosophy. So let's consider do we have a natural right to liberty? And this was what the classical Greek philosophers debated quite often. And in modern governments, we find that they have more extensive powers than the minimal state that the liberals first envisaged the libertarians back in 200 years ago. And why is that? So historically, we have moved past the reasons for the flourishing of this liberalist tradition, in my opinion. So the reason for the development of this tradition was as a reaction to tyrannical governments and like overly powerful monarchies. We only have symbolic monarchies throughout the world today. We don't have those kind of monarchies that had centralized power. So as people, we tend to forget what has come before us. This is the basis for that common idea that history repeats itself. So the question is to do with whether humans have a right to negative liberty given the nature that we have. Regarding that, the idea of fundamental human rights is closely linked to the tradition or scholarship or literature regarding human dignity. Now, most of us, through the way that we were brought up in this culture, the spread of those common ideas, would not dispute that humans have a right to freedom from constraint in things that don't harm others. So in terms of negative liberty. Compare this to an argument that holds that humans have a right to positive liberty given the nature that we have. So what that basically means is that humans have a natural right to live prosperous economic lives. and be financially and socially on equal footing to each other. So the focus here is on the outcome, is on the fact that we deserve to live good lives, like flourishing lives, not merely have the opportunity to live that way. And now, peachy as that vision is, as ideal as it is, consider the political implications of this latter argument. Now, who will be obliged to provide that equality of outcome, that economic security? The state? The citizens around us? And then think about, in realistic terms, how that will be achieved. Will it be via taxation of everyone so that everyone is given equal distribution of income, or the means of production? What about through a revolution that enables a new government to be formed to allow that? Now, after that revolution, what does that mean for the size of the state? And more specifically, what does that state comprise? It will be a group of individuals, right? Does this bigger state comport with our knowledge of human nature and power in our experience? Will that result in an equal outcome for everyone? Do states with more power use their power to give liberty back to its citizens, according to human history? These are some questions you can ask yourselves. And they connect all to the importance of liberty and having that fundamental liberty in our lives. All right, so let's have a look at the unlikely marriage of evolution, law, and liberty. The best means to protect individual negative liberty is by first understanding human nature and the broader patterns of behavior. So behavioral and biological sciences have been key disciplines which have informed liberalism in the last century. So first, to understand evolutionary legal concepts, we must first understand the underlying concept of evolution, right? The idea of evolution is the most familiar within biology, and it refers to changes that occur within a population over time. The most influential work in the study of biological evolution is, of course, attributed to Charles Darwin's The Origin of Species, which was published in 1859. And a key process that comes out of that book is Darwin's term natural selection, which he believed was the process driving biological evolution. So he basically stated that individuals within a population who are well adapted to their environmental conditions have an advantage over those who are not so well adapted. The well-adapted organisms are more likely to survive and reproduce. Inherited traits of well-adapted organisms are more likely to be passed on from their offspring to the next generation. And over time, the traits that help the organism survive are more likely to persist. It's also important to know that there is a natural proclivity among all living things to survive. All right, so in that sense, they can be self-interested if it means that it will guarantee their survival. That is the basic premise of biological evolution, but Darwinian evolution is a theory which is basically restricted to biology. However, what happens is that there is this idea of interdisciplinary fertilization, whereby some theorists then apply this evolution type concepts to the study of other parts of human society. An early theorist to apply evolutionary type concepts to economics and morality was the Scottish philosopher Adam Smith. Smith wrote almost a century before Darwin and did not use the terms evolution or natural selection. However, some of his thoughts bear marked similarities to evolutionary ideas, and basically, I guess, because we see what's going on around us, he could have been inspired by that pattern of behavior. So in the Theory of Moral Sentiments of 1759, Smith applied an evolutionary type analysis to morality. Later in The Wealth of Nations, 1776, he applies a similar methodology to economics, and I'm going to look at the economics most specifically. Smith's most famous concept that came out regarding economics is the invisible hand. And he used this notion to explain how economies organize themselves in the absence of a central planner, right? So Smith noticed that in the market, individuals pursue their own self-interest, adapt to existing economic conditions. They seek to sell products for a profit and buy what they want as the lowest price. And this comes naturally to us. Whether you're a haggler or not, you want to buy something at the lowest possible price, right? Smith made a number of important observations about the operation of markets. The markets tend to coordinate itself by matching supply and demand, and economists sometimes call this market equilibrium. Smith also emphasized the central role of the division of labor in markets. So over time, what he basically said is that this pattern of behavior where humans seek to sell products at a profit and buy at the lowest possible rate means that at a certain point, the price mechanism will guarantee that the market reaches an equilibrium. And this is done through this force that's not a result of a central planner called the invisible hand. So he points out the mutually supportive role of markets and social rules. In a market economy, people cooperate to get what they want. And as a result, common principles of behavior tend to emerge. So we know that certain social rules are necessary for us to cooperate with each other so that everyone wins. It's a win-win situation. Smith noticed that the market economy often works in a rational way. So it brings us back to the classical Greek philosophers who believed that the cosmos, the whole world, worked in a rational, was constructed in a rational way. This makes it look as if there is an invisible hand organizing it, so very reminiscent of cosmology. Smith used the invisible hand to describe the way the economy organizes itself, and it leads us to this idea of the spontaneous order. So an order that arises spontaneously and without being centrally planned. So this is a central concept to evolutionary theories, the idea of the spontaneous order. The rules of a spontaneous order are not premeditated or planned in advance, but evolve over time organically. So in a spontaneous order, people adopt the practices that they think will best enable them to coexist in this social environment. If the practices do not work, they are abandoned for more effective approaches or strategies. And a process of trial and error is adopted to reach a social consensus, or in economic terms, the equilibrium point, right? So let's have a look at the point where biological sciences, this idea of Darwinian evolution was used in terms of law and liberty. Friedrich A. Hayek, he lived from 1899 to 1992, and he's basically the leading figure in contemporary evolutionary legal theory. And he published widely on topics like law, economics, politics, and sociology. His two main works on legal theory are Law, Legislation, and Liberty and The Constitution of Liberty. And his best-known book is The Road to Serfdom, a popular critique of socialism. He also wrote a less well-known but central work titled The Fatal Conceit, The Errors of Socialism. And it can be best considered as an exposition of his first principles or premise of his political and legal theories. So in this work, he makes a realistic claim that as unsavory as it is for us to accept or admit, humans are fallible. Like, we make mistakes, whether through cognitive bias or self-interest or just pure human error. We are far from perfect. An account of human fallible nature is, he believes, continuous with natural selection to a certain degree. And by particular reference to political context, he says that humans are naturally also afflicted by a blindness to our own shortcomings. He calls this blindness the synoptic delusion, which basically means humans habitually believe that better systems of government, economics, or law are those that are centrally planned, right? So they have to be ones that are controlled by humans, that are organized by humans and planned in advance. which involves more human intervention and control and less liberty. He suggests basically that this flies in the face of patterns of biological science, rationality, human nature, and our knowledge of human history as well. And we'll return to this point. He introduces two concepts, cosmos and taxis. Now, cosmos and taxis are two types of organization. A cosmos is a bottom-up type of organization. The rules of the organization emerge spontaneously as the consensus of all the members. So through cooperation between members to maximize advantage to all, a bottom-up sort of organization emerges. A taxis, by contrast, is top-down. So the rules are planned out beforehand by a select few, usually, and those at the top of the hierarchy impose those rules on those below. So Hayek draws on the notions of cosmos and taxis to present two claims about law. And these we might call them his descriptive thesis, so the way things are, and his normative thesis, which is a thesis about the way things ought to be. So Hayek's descriptive thesis of the law generally is a cosmos rather than a taxis. This is a factual claim about the dominant character of law and legal systems. Now, Hayek's normative thesis is that law ought to be a cosmos as well, as opposed to a taxis. This is a prescriptive or moral claim about the legal system, and in both instances, he believes that it has to be a cosmos as opposed to a taxis, for it to firstly, that is the way it is, if you leave it be without trying to control it, and the second is that ought to be the way it is because it's most ideal, morally speaking, in terms of what it's meant to be. So Hayek also notes that cosmoi and taxis are governed by different kind of rules. So the type of rule that is found in cosmos is called nomos, while the type of rule that is found in taxis is called a thesis. Hayek observes that nomoi tend to be general and ended dependent. Now, since these rules arise from individuals pursuing their diverse interests, they need to be compatible with a variety of different purposes. So basically, in Hayek's view, if you just let the economy regulate itself, what individuals are diverse by nature, that's the way they are. So then by pursuing their various interests, this will bring about rules that accommodate for those diverse interests, as opposed to a taxis system which tries to impose diversity rules and inclusivity rules from top down through power in the hands of a few. So theses, on the other hand, tend to be specific and end-oriented in character. So there is a specific goal in mind with theses. So if you wish to control an organization from the top down, you must give specific directions to those below you in the organization. It requires being given certain directives, right? And those directions will reflect your sense of the purpose of the organization. They will be directed towards a particular outcome rather than allowing individuals to pursue their own goals, right? So there'll be far less individual freedom for you to pursue your own diverse goals if an organization dictates that diverse goal for you and directs you to that achievement of that particular end. So the basis for Hayek's normative thesis is that law ought to be a cosmos rather than taxis. Hayek does not suggest the idea of a cosmos is good in itself. Rather, this model of law, he says, is best suited to achieve two other values that are essential for human welfare. And law as a cosmos, firstly, secures liberty. And law as cosmos facilitates the pursuit of knowledge. And those, he thinks, are two primary values that are in and of themselves important fundamentally. He doesn't believe that cosmos is the good in itself, but they are two primary goods that it better facilitates the protection of. All right, so that point brings us back to the point of the synoptic delusion. Hayek says that those who think all good law must be the work of a central planner are suffering from this ailment of the synoptic delusion. Now, the synoptic delusion says that if something is well organized, some individual group must have been responsible for planning it. And that seems intuitively correct, right? But he's saying that that is a delusion. Hayek points out that this assumption overlooks the possibility of this spontaneous order that arises, which is the way that human behavior or the patterns of scientific biology exists in the world. So in a descriptive sense, so factually. So on this basis, Hayek launches a critique of what he calls constructivist rationality. Constructivist is the idea that all worthwhile human institutions can and should be planned by human rationality and must be constructed, socially constructed. The constructivist, according to Hayek, has an inflated view of human knowledge. So there's a lack of intellectual modesty here, basically, in saying that everything that we look at around us has been created or constructed socially. He believes that that's not only factually incorrect, but that it is also morally incorrect and normatively not ideal. Because what it does ultimately is fails to protect and actually encroaches on and curbs these other two very important, intrinsically valuable ideals of knowledge and liberty. All right, so the advantage of a spontaneous order is that it draws on the collective experiences of the whole population over a long period of time. And these experiences are reflected in the evolved social practices. It follows that spontaneous order does a much better job at organizing society than any certain individual or, group of individuals can, right? So it borrows on the wisdom of everyone in society over a long period of time to bring about these practices. So a good example of that in society, he says, is the conception of common law. So this kind of spontaneous order basically leads Hayek to favor common law, so judge-made law, so a long series of judgments over centuries, over statute or legislation that's basically delivered by a parliament, the incumbent at a certain specific time, and then disavowed or maybe suspended when a new incumbent comes through. So legislation makes the legal system resemble a taxis, he says. It is a top-down method of lawmaking where the legislature imposes its transient priorities upon the citizens. And parliaments have agendas usually, and not all citizens in a democracy vote for that incumbent, by the way. So even if it's 51% who voted for the incumbent, the view of the 51% will dominate 100%, including the 49% that voted against. So that's a very top-down, premeditated way of organizing legal systems. So legislation tends to have the character of a thesis. It is typically aimed at securing a particular policy objective by controlling social action. Hayek believes that common law, on the other hand, is like a cosmos. It arises from judges using pre-existing social rules as a way to decide specific cases that come before them. The judges are not imposing their own views on the citizen, but they're applying existing social norms. And even if they go beyond the pale when it comes to a little bit of judges are prone to activism, they can only affect that particular case or that particular factual scenario, which then can be, if another case comes before the court with similar facts, the next group of judges or a judge can distinguish and deliberate differently, right? So over time, this will change the assessment of that particular fact scenario using the social practices or reasoning standards at a given time might is prone to evolution over time. The judge-made law, according to Hayek, tends to be more general and principled than legislation. And also judges are held accountable because they have to make their judgments public. Their deliberations also public, right? It is not based on pursuing particular goals. It does not advance their individual interests, but applies pre-existing principles. We can see from this that Hayek takes a conservative view of legal reform. He basically argues that legislature should not attempt to radically social change things in society. So he's obviously anti-activism, judicial activism. So rather, legal rules should only change when the social consensus changes, and this ensures the legal system retains its character as a cosmos. The merit of judge-made law, another thing that he points out, lies in this idea of the common law method, which is the common law tradition we inherited from Australia. We inherited from the British. Judges do not make law, but merely apply it. They are bounded, ideally, by the doctrine of stare decisis, to rely upon existing precedents to decide cases. So they're still bound by this long line of cases. They can't just go on a frolic of their own and decide the cases they deem fit at that particular time according to their personal political views or ideology. The common law thus brings stability to the law. It makes the law predictable and consistent, right? And it's prospective, not retrospective. So it favors an incremental model of reform to the law. The law changes gradually through precedent rather than radically through fundamental change top-down, like through parliamentary changes. Even referenda are a rule by a majority of citizens. So it's not the same. Who could be swayed by a certain ideology at that given point in time, and it still affects the whole nation. So as opposed to that, the common law method is a lot more stable, it's more predictable, it's consistent, and it can still be changed, albeit slowly. Whereas things like a referenda, you cannot change it once it's in law. It's very difficult to reverse. So Hayek argues the common law method ensures law reflects evolved social standards rather than being imposed upon society by a central planner. So Hayek's political theory then would also closely align with his legal theory. He is usually described as a classical liberal or even libertarian figure. Hayek believes that liberty is the most important political value out there, and this explains why he supports rigid constitutional restrictions on the power of government to allow maximum scope for individual autonomy. And so according to Hayek, the Constitution's purpose is to limit government power so that abuse does not occur. So the reason Hayek wants the power of government to be strictly limited is that otherwise law will resemble a tax system, a top-down system where the government imposes its own priorities and values on the community. And the role of the government should be limited to enforcing evolved social norms and no more than that. He believed that if we allowed spontaneous order to emerge and function, individuals are able to exercise their liberty without the need for excessive legal interventions. And this allows for a greater degree of personal freedom and autonomy while also promoting the greater good of society. So to conclude this video, while the relationship between liberty and law is complex and often fraught, Hayek's theory of spontaneous order suggests that the best mode for protecting liberty is through the natural emergence of order in society. By allowing individuals to freely interact with each other, we can create a legal system that protects individual freedom while also promoting the greater good of society without subjecting ourselves to tyranny by thrusting ourselves into the power of a fallible group of individuals that have limited information at a specific time in history, but they basically comprise a state or political body. So this is Hayek's political theory in action. And he basically says that some of these assumptions lead to smaller government, and it leads to a classical liberal philosophy. So thank you very much for joining me today for this video. I think it's quite an important topic that we need to all be considering as, in a representational democracy where we hold the value of a vote. So I'll hope to visit you again soon with another legal philosophy video. Thank you. Bye.